Hi, welcome to Matters of Law. Matters of Law, the law reigns supreme. Catch us on YouTube on extvgh and on Facebook on extvgh. Today, we are talking about will. Wills. Let's go for a commercial break. We'll be right back.
This program is brought to you by PEG Enterprise. Call us on 0240 533 097 0240 533 097 for your delicious pastries, cookies, and drinks. Locate PEG Enterprise near Keke House in Ho.
Welcome back. Wills. That's what we are talking about. How does one make a will? What are the processes to follow to make a will? Of late, the subject matter of wills has become a very topical issue. We need to understand that you can only give out a self-acquired property. But before then, who is qualified to make a will? Under our Wills Act, it's persons who are 18 years and above, who are of sound mind, and have property of their own who can do wills. The only exception as to the age requirement is persons who work within the armed forces. Now, once you are saying you don't have any problem with your mind and you understand clearly what you want to do, then the law allows you to give your self-acquired property out. You cannot give family property out in a will. You cannot bequeath estate property to any person. You can only give out your self-acquired property. Now, who can benefit from your will? Your family and any other person you choose to give your will to, you give your property to, can benefit from the will. The key thing you need to know is that the will must be in writing, signed by the testator or testatrix. That's the person making a will. If it's a man, it's a testator. If it's a woman, it's the testatrix. And witnessed by at least 2 witnesses. If that person making the will is an illiterate, then the person will need the will to be read and interpreted to him by somebody, and the person's name has to be indicated, what we usually refer to as the jurat. And somebody must witness the jurat that has been executed or has been written. Now, one other thing you need to know is that you must always ensure that it is your self-acquired property that you are giving out, or the portion of a property that you co-own with somebody that is yours that you are giving out. The beneficiaries of a will are those who you are giving the properties to. Now, before we even talk about beneficiaries, you need to appoint executors of your will, at least 2 executors. These executors will ensure that when you pass on, they will go and obtain what we call probate from the court. The will first of all be read, then they'll obtain a document from the court, apply to the court and obtain a document called the probate. That is what they will use to be able to administer the estate or to ensure that the property is shared according to the legal requirements in the will, or the dispositions that you have given the will, or how you have shared the property in the will. You need to provide the names and residential addresses or the postal addresses of these executors. Now remember, the people who you are giving the property to as beneficiaries should not be the ones who serve as witnesses. You could give the property to family members, you could give it to a church, or you could give it to an organization. You could create a trust or give it to any other person you so wish as the testator. In all of this, you must see a lawyer, because there's a lawyer who prepared the document for you and will put it in fine legal language. After you are done preparing the will, the lawyer may choose to lodge it at the high courts or lodge it in any court and give you copies so that you keep. So 4 copies may be made. 1 copy will be kept at the court, and 3 copies may be given to you that you keep in your safe depository, or you share to people who you want to keep your will. Upon your death, they can bring it out, the will will be read, and the executors will apply for probate. Now, assuming Kofi has been given a house in a will, right after the executors go for probate, Kofi does not automatically get the house. there needs to be a document which is a vesting assent to be prepared for you, the one who is the beneficiary, for you to be able to have that property vested in you or the property be in your name. Also, in a will, it may indicate that one or more people should enjoy a particular property, either tenants in common or joint tenants. If they are to enjoy it as tenants in common, then that means they have common shares. They have a portion that is to them. It goes along with them. They can also give that out, or they can give that part as part of their inheritance. But if they are enjoying the property as joint tenants, then they enjoy the property till their life ends. After their life ends, whoever is the other tenant would have what we call the right of survivorship. So whatever you were entitled to, Mr. A, whatever Mr. A was entitled to, when Mr. A passes on, when Mr. B is alive, Mr. B takes whatever Mr. A was already entitled to. So he takes Mr. A's share and his personal share. It is important for us to know that once you see a lawyer and prepare this document, you are good to go. Nobody knows when he or she will die, but it's important to prepare and do your will. It may be personal effects, it may be land, it may be a house, it may be a farm, it may be even the balance in your bank account. And remember, when somebody dies and has made a will, until probate has been obtained, you cannot go and use his ATM, or you cannot go and withdraw any cash from the bank. Now let's do a quick summary. You can only give what you have. Nemo dat code non-habit. You cannot give what you do not have. Make sure that you have 2 witnesses signing. Have a lawyer prepare the document for you and let it be lodged. You can do your will now. See a lawyer and you'll be very much sorted out. Thank you so much for watching this edition on wills, on matters of law. Matters of law, the law reigns supreme. Share this with friends, colleagues, and others who are interested in this subject matter. Watch us on extvgh on YouTube and Explore TVGH on Facebook. Thank you.
To support this program, contact XTV on 024 606 1095 or 050 836 4159, or send us an email to info@extvgh.com.